Justice. Very good morning to the distinguished judges, everyone in the room. This is probably the first time that an MCIA event has started about 10, 12 minutes late. And I blame two things for that, right? BCCI and also the fact that I think MCIA was rather generous with the drinks last night. But welcome, thank you all for making it this morning. What a week it has been. We're in the 6th day of this ADR week in India. And I just want to spend a minute talking about this journey. When MCIA was set up 7 years ago, I remember having this conversation with Madhukeshwar and Niti and saying we need to have a conference in India that MCIA puts forward. And I said, it's got to be a full-day conference, full of thought leadership issues, etc. And both of them said, in relation to arbitration, it doesn't happen in India. No one will leave the courts and come and attend a full day of events where people talk about arbitrations. We did it anyway. Each MCIA conference has been sold out. Then we said, all right, let's be even more aspirational than that. And that's where the idea of an ADR week in India was born. Fast forward to 2023, we've had 5 full days of events so far across 3 cities. Each of those days has been sold out 3 weeks in advance of the day itself. So will you join me in congratulating MCIA and Madhukeshwar and Niti on what was thought to be impossible to do within the Indian context. But it's not just about arbitration conferences, right? It's about the growth of arbitration within India itself. So when I think about 2015, 2016, and I think about 2023, I think India has moved in the arbitration context by leaps and bounds. People coming here, exchanging ideas, talking about the arbitration issues is one part of it. The judiciary is actively looking at arbitration-friendly pronouncements. The legislature is looking at how to make the arbitration scene from a legislative perspective more active. So all of this bodes tremendously well for India and for the consumers of arbitration, and that's something to be celebrated. In the few minutes that I have to give my opening address, I just wanted to touch on a few other things. First, in terms of arbitration and how MCIA has helped, certainly what it's done is it's set a standard for how arbitrations ought to be done in the Indian context. An international standard has been brought into the country. And to some extent, it has also inspired other institutions in the country to take shape as well. And that's to be celebrated, because that is what one requires for an arbitration ecosystem to develop. Now, I practice in Singapore, and that's how the arbitration ecosystem in Singapore developed to some extent as well. You would have seen from the program that all of the new institutions were part of ADR Week. They were here, they presented their respective perspectives, and that too, I think, is what one needs to develop that ecosystem. So it's not just about MCIA. MCIA has curated this program, but really it's been inclusive, and I think that's to be celebrated as well. MCIA, on its part, I think can be proud of the fact that, true to its origins, it is first, I'd say, international arbitration center in India that has been operating with rules to international standards, with a council of both top local practitioners and also international practitioners, but also one that is truly independent of merchant chambers, independent of the government, independent of other government bodies. So I think that independence will also stand it in good stead. What it has also embarked on in these 7 years is capacity building. For example, on the sidelines of the ADR week, they have recently conducted tribunal secretary training. So the idea is that you bring in the younger generation into the arbitration world, train them on how to assist tribunals in deliberations, and that is now going to spawn, I think, the next generation of the arbitration bar within India. Related to that, I'm pleased to report that we have Alex from Jus Mundi in the room. Jus Mundi would be familiar to all of us as legal practitioners, a very large international organization of lawyers and law firms. MCIA is going to be entering into an MOU with Jus Mundi to publish redacted awards through their platform. And also, the tribunal secretaries that have been trained through that MCIA program will now be projected into the world through the Jus Mundi platform, so that arbitrators that require tribunal secretaries can then have trained tribunal secretaries assisting them moving forward. But it also gives those young tribunal secretaries an opportunity to be engaged by arbitrators from around the world. So I'm really pleased to report that, and we look forward to that being a hugely successful venture. Obviously, redaction of awards is something that's taking shape, because the arbitral world is recognizing that the development of arbitration law, while respecting confidentiality, needs to take place, because that is how arbitration jurisprudence will develop, particularly given that, by and large, in international commercial contracts these days, arbitration is the preferred mode of dispute resolution. Finally, I'm going to take this opportunity once again to highlight a few other things. One, transcription. You'll see that the entire event, those of you who've been here through the week would have seen the transcription on the screen. Now, this is again something that MCI introduced at the very first conference, right, from day one. Now, I remember at the time people coming and saying, is everybody reading from a script? Because it all seems to be coming up on screen. Did you have that in advance? And we had to explain to a number of people that had never seen live transcription that no, this is happening live. But again, from an Indian perspective, let me share another development. When we did that till now, it was through international service providers, Opus and Epic and the like. Today, what you're seeing on the screen is something done by an Indian service provider. So again, something to be celebrated. And I hope that Terrace, that's doing this, and I understand they're also doing it in the Supreme Court context, will have much success. And it just reflects the growth of arbitration within India. So congratulations to MCIA for curating an amazing ADR week. And we look forward to the final deliberations today. And without further ado, I'd like to invite the panel to begin its deliberation.
Thank you, Mr. Shetty. I would now like to introduce our guest of honor, Honorable Mr. Justice S. Muralidhar, the former Chief Justice of the High Court of Orissa. Justice Muralidhar was appointed as the judge of the Delhi High Court in 2006. He later also served as the judge of the High Court in Punjab and Haryana. In 2020, Justice Muralidhar was appointed as the Chief Justice of the High Court of Orissa. With this, I would like to invite Justice Muralidhar to please address the crowd.
A very warm good morning to everyone. Justice Bhat, all the distinguished participants, both off and on the dais. The nice thing about this gathering is also what you people don't see. There's a clock which runs down. So it tells you exactly how many more minutes you have to suffer, all of us. And it right now says 36 minutes and 27 seconds. I am as keen as all of you to listen to Justice Bhat, so I'll cut down what I have to say. I've been now part of some of these ADR week events, and I would agree with Mr. Shetty that this is a welcome move for exposing the Indian bar, arbitration bar, to the trends internationally, and the good practices that are happening abroad, and which is what we want to emulate. We keep talking of CIAC, London International Arbitration Center, and all of that. We have our own versions of international arbitration centers now in many cities. And they have a set of rules. And just as Mr. Shetty was saying, we are trying to see how we can regulate arbitration work so that we keep some norms. Simultaneously, there have been some changes statutorily brought about. So the two recent changes, and people in India are of course aware of it, the two recent changes are the setting of the India International Arbitration Center, which is now headed by a former judge of the Supreme Court of India, Justice Hemant Gupta. And just 2 days ago, on 12th October, the central government notified Section 10 of the Amendment Act of 2019, which sets up what is called the Arbitration Council of India. Now, this Arbitration Council is some like kind of an accrediting body, which will accredit not only arbitrators, but arbitral institutions as well. So what is interesting is, while they've notified Section 10, which brings about the Arbitration Council of India, of course, they'll go through the process of appointing the council itself. There is one provision which has not been notified, which is Section 14 of that Amendment Act, which introduces the 8th schedule, which actually sets out the norms for accreditation. Now, 8th schedule needs the government to consult with the Arbitration Council of India, and perhaps that's why they've not notified it. But it will be interesting to see how this plays out if we actually start accrediting arbitrators, notwithstanding that they may have been former judges, because the presumption is not every judge makes a good arbitrator, not every lawyer becomes a good arbitrator, and we need to widen the range of persons who can act as arbitrators, particularly given that many of the disputes cover very niche areas which require specialization, specialized knowledge of the disputes arising in that area. So I think this would be a welcome move, but we'll have to see how this plays out. The point I'm making is, I think there is a greater awareness of the need for norms to be set in, greater need for accountability. When we fix time limits, when we say the quality of the award, we're asking for some accountability. In fact, part of the provisions, it's now written into the provisions. If I just read out Section 43I, general norms for grading of arbitral institutions, and I'm sure all the, including MCIA, would be interested in this. The council shall make grading of arbitral institutions on the basis of criteria relating to infrastructure, quality and caliber of arbitrators, performance and compliance of time limits for disposal of domestic or international commercial arbitrations. So I think there is an emphasis on accountability, and this statute also asks for maintaining a repository of arbitral awards. So that would also bring in some kind of a control of the quality of arbitration that happens in these institutions. These are welcome changes, and if it can help us upgrade ourselves and go to the next level, then this change is, of course, most welcome. And I'm looking forward, because I've just retired 2 months ago, and I've just begun doing some arbitrations. So I'll be interested to see what impact these changes bring about in the quality of arbitration. So thank you for listening to me. I'm equally keen, like all of you are, to listen to Justice Bhat. Thank you.
Thank you, Justice Muralidhar. I would now like to introduce our chief guest, Honorable Mr. Justice Ravindra Bhat, Judge at the Supreme Court of India. Justice Bhat was appointed as an additional judge in the Delhi High Court in 2004. He later became a permanent judge at the Delhi High Court in 2006. In 2019, Justice Bhat took oath as the Chief Justice of the Rajasthan High Court, and in 2019 itself, Justice Bhat became a sitting judge at the Supreme Court of India. With this, I would like to now invite Honorable Justice Mr. Bhat to please address the crowd.
Good morning to all of you. Distinguished panelists, I would say distinguished members of the audience, many of them friends, Justice Muralidhar, a very old friend. It's very gratifying to be here speaking about arbitration and arbitral institutions. I am an unlikely entrant, perhaps Justice Muralidhar too. We had very little arbitration experience as practitioners, and I remember distinctly in one case we opposed each other as well. But coming back to the main theme, what is particularly gratifying for me is almost the end of the journey, as it were, to see something being brought to fruition. Why I say this is because in 2009, when we had a very dynamic Chief Justice, Justice A.P. Shah, he set up a committee to recommend the formation of a center, an arbitral center, and we did come out with it. I, Justice Sen and Justice Sikri were part of that committee. And we came up with the blueprint for the rules, etc. And then we did set it up. And I think Niti was part of that too for some time. So that was a learning experience for us because the setting up of it, the running. I was initially a member of the committee which actually oversaw its administration. Later I chaired it for 3 years. And that experience helped me also make my comments known to Justice Shah when he was in the Law Commission on both the Commercial Courts bill as well as the amendments to the Arbitration Act. Well, as they say, one or two things were eye-openers and which are very relevant topics today. That one was particularly a visit to Melbourne, where we went on. The present Chief Justice of India was also an invitee, so there was a law and technology event, conference. So in that, we were exposed, and I was particularly fascinated by we had our own version of digital courts functioning, and probably the two of us were pioneers in the Delhi High Court. So those systems were there, but what really intrigued me was a common filing system that they had for the federal courts. And what is more, in the context of arbitration, they had developed one or two extremely good procedures. One judge told me that he would, in this construction litigation, where you have masses and masses of documents, he would obligate the parties to what he called as deduplicate. You have multiple copies of the same documents thrown at the court or the arbitrator. That itself occupies maybe 1,000 pages or thousands of pages. So he said, it's your job to deduplicate. And he said, if the record is something like 500,000 pages, then he would mandatorily ask for a technical man. AI tools were just in the offing, they were in their infancy, but then they were used. So particular softwares were developed, and he would reduce the mass to about manageable limits to 50,000, etc. So this was an eye-opener for me. Within a few months, we all became part of the official arbitration reforms committee, and I remember distinctly they just very actively associated with it, and it's very gratifying today to be told that the arbitration council is being set up. And also many of our recommendations have now become law. But what really matters to me, beyond the law, beyond the structures that have been conceived and have been brought about, is to the extent to which arbitration culture has been inculcated. And I see that it's quite a robust one, that this robust culture of arbitration has to translate into what I visualize as full-time arbitration lawyers. I know that there are some, but I want an entire arbitration bar. I think then we would have really arrived home, where entire sets of lawyers are only arbitrators or arbitration, those who practice in arbitration law, and don't look at litigation as the main source, rather the litigation as the secondary source. So I see that some people have specialized, but I would really think that we have arrived when we reach that. And they occupy positions of influence. Because today we are still at the stage of institution building and coming up with standards and norms. The Arbitration Promotion Council is expected to do that. That's precisely the reason we conceived of it. How well it succeeds depends on us. And the kind of norms we can evolve, the best practices for arbitrators, institutions, and the push we give. For me, it's also very important that mediation is dovetailed into this. because the mediation movement also should go beyond judges and lawyers. And if it has to take roots even in arbitration as a first option, I would say if it's there in institutions, it should be made mandatory that you go through mediation for a limited time period and then launch into arbitration. So many of these ideas are there, but I think really the ultimate taste of the cake, if I may say so, is how many of what is going out from here is going to be retained, references. And that, I think, is a larger culture we will have to address. It will take perhaps a longer time. The awards which ultimately are delivered here, if they have to reach Indian courts, the arbitration culture in the courts is something we have to develop. And I would take that as a challenge for all of us, because we have developed expertise, so to say, in some cities, Mumbai, Delhi, perhaps Chennai. But the rest of the country, we have to see that this culture goes forward. As in mediation, there has to be a very conscious push to see that these institutions are developed and popularized. And it is not only the commercial arbitration of the high-end kinds that we see being promoted, but that this culture should translate down to different places, tier 2 cities, etc. And what actually set me thinking is there are large masses of people who get drawn into arbitration because of the kind of contracts they enter into, but are unable to sustain the proceedings because they are not able to pay. So typically hire purchase contracts, insurance policies, smaller insurance policies, and not the Halliburton type. So these people need to have some kind of a neutral venue, and therefore I would feel that another side project which institutions can take up is pro bono arbitration, pro bono arbitrators, because we do need them. And it's possible that both parties have very modest means and yet are traders. But the idea is, why should they be driven to the court and this option be only available to those who can afford? So I would request all of you to take this thought and work upon it. I see that your conference today has a lot of content on AI, digital evidence, etc. I don't think we would have been speaking as much as we are today, but for the pandemic. That's one of the things we have to thank it for, because it gave us a completely new world of possibilities, and we have cashed in on it. And there's a very conscious push that, online arbitration, I think it's now taken for granted that at least many procedural hearings, perhaps depositions, take place online. And as Mr. Shetty said, even as we speak, what we say is recorded and it is available. I was also a witness to it, because the first time we did that in the 5-judge bench hearing in the Supreme Court. So all this is rapid, I must say, but at the same time very welcome. And the sooner those of us who are in places of doubt adopt it, the better for us, the better for the system. And the last thought which I wish to share with you is, I think it's a great thing, this idea of training, because you mentioned about training the secretaries. Well, this training is something which I would again earnestly request all the institutions to come together, not only train young lawyers, but train judges, and engage actively with the judicial academies. We have a number of at least 15 or 20 judicial academies. And that's a very good catchment, because that's where you can collaborate with the institution, the judicial education institution, and the judges who can be the catchment. They have to be taught. You may devise short courses, and then you may engage with them. Many of them are as young as the secretaries whom you have trained, but they're spread out. So I think this culture is possible when you train judges, you train lawyers. And this if you can, even the training sessions that you had, the course, if you have visual recordings, etc., you could consider the manner in which you can share it, because then you can have a much wider audience. Likewise, you could even think of online courses, short courses, accreditation courses for many topics, for lawyers as well as even arbitrators, and you could have capsules. So these institutions should be, in that sense, thought leaders also, and you should have separate academies or some kind of cells, or collaborate and join together and create them. So the same emphasis, I would say, is your spread of awareness to educational institutions and universities. If you can join together and create chairs in universities, and eventually the dream is to realize something like what perhaps Niti went to, Queen Mary or Stockholm or something like that, or MIDS, where we have world-level institutions. So we should think of that. That should be the ideal, that should be our dream and our vision. So once we think of it and plan for it, it will happen. But it may not be in the immediate future. It may take some time. But it is necessary to happen if we want to ensure that arbitration has meaning in India and relevance in India, and our references don't move out as often as they do now. So I think I've spoken enough. I came with a prepared text, but I decided to completely abandon it, and I hope whatever I spoke made sense. Thank you very much.
Why don't I kick it off with the first question? I'll give you some time to think about yours. Actually, I was very interested to hear, Judge, your comment around training for the judiciary. Again, I'm coming in here, obviously, as an ethnic Indian, but not someone who practices in India. I practice in Singapore, so forgive my ignorance if I don't know how that's to be done. But it's something that I think we've discussed at the MCIA level many times, including yesterday, as to how one would go about presenting that option to the judicial academies to say that, this is something that we would be able to facilitate, both with practitioners on the ground in India and also international practitioners, to have that discussion with judges and exchange ideas. If you have any thoughts on that, please do share.
Both I and Justice Muralidhar have actively associated with judicial academies. He is more active now because he has always been active, but I think his new inning has made him more active, has given him more time. So for the past 10, 12 years, we have engaged with the academies. And perhaps the problem is that we have seen these two places as in completely different compartments or silos. It need not be so, because let's say, audience, on many occasions in the National Judicial Academy, we were exposed to a range of ideas, presented by different kind of experts and different kinds of people who came, people who headed movements, people who had ideas, who had author, people who had spoken, written, economists, etc. So these are good places where one can associate with. And if you are in a position to design a program and put it together, you can actually go to these academies. Start with the National Judicial Academy. That would be a good place to start. I don't know what Justice Muralidhar feels. It could be a 2 or 3 day program, and it could be curated in such a manner that experienced judges are there as resource persons, plus some experienced arbitrators, and even lawyers. So you'll have a completely 3D perspective, so to say. And then if you collaborate and these ideas are well taken, the NJA tailors programs, they settle a schedule or a calendar for the year. So in that, the state academies are signed on. So the state academies could also then agree to have programs, periodic programs, and sometimes even refresher programs. So that's the established way in this. This is how it is done. Yeah.
Thank you, Judge. Justice Muralidhar, did you have anything to add?
Okay.
If you have something to add to that.
One is just sharing with Mr. Desai. See, the habits of the regular practice, whether as lawyers or judges, we bring it into arbitration. Whereas all of us here are trying to reverse that trend. We want the best practices of international arbitration to inform the way we will function. So we have to get rid of, it's like an unlearning and relearning. And I'm deliberately using that phrase because that relearning requires a willingness. What we found in the judicial academies is where in the judicial hierarchy, one level of judges are amenable to this relearning. Certain judges at different levels find it difficult to, come for these kind of courses. So I would agree with Justice Bhat that this needs to be a specially designed course. I would advise to have international resource persons, people who've been part of SIAC, London International Arbitration Center, to discuss what is the method of award writing. I've had some judges, former judges who've become arbitrators, tell me that it's very challenging because if you've been an appellate judge in a high court, to actually begin to start writing as a trial judge, and which is what an arbitrator is required to do, like framing of issues, discussing evidence, addressing each argument. So it requires a different mindset and different approach, absolutely. And then second is about organizing yourself. See, the way we have organized ourselves for work as a judge in an Indian court, organized as a lawyer in the Indian bar, is at one level. But arbitration requires organizing yourself at a different level. If you have to stick to timelines, and you should know how to use your resources, like this transcription, for instance, or paperlessness. Using law researchers. I know judges who have law researchers but don't know how to use the law researchers. So there is an overall training or relearning that requires to be done. And this would be ideal if you design what we call a niche course, where you have, as Justice Bhat was saying, resource persons will be practitioners of arbitration law, whether it's lawyers or judges. And if they can be from abroad, it is even more convenient to know what are the best practices.
Thank you, Judge. Of course.
I just want to add one more thing, that, just to address what Justice Muralidhar said, that there is a certain section which is always amenable, willing, with open minds. But there's another section which you can't ignore, and many of them could be could have long tenures, and they could have very entrenched and very rigid ideas. So I think it does, whilst there is a lot of merit in getting international resource persons, I'm not discounting it, I think it's also necessary to have some peer people who are willing to say the realities, to say the truth. For instance, typically in one of these sessions, I was asked to speak on international arbitration and the relevance of arbitration in those early days. And fortunately or unfortunately, we had the white industries experience, and then we had also the whole dispute in Bolco. So I thought this is the best time to give a shock treatment, and I said, look, we are going to suffer an award or something like that for so many $1 billion, and there are other claims pending. If we don't mend our ways, and if we don't ensure that these matters are heard and done within a certain time frame, reasonable time frame, we are responsible for whatever happens in the economy. Don't forget that. And we have to, and somebody who's willing to speak these realities and home truths needs to be there as well. So where I have no difficulty agreeing with Justice Muralidhar about getting the best international experts, it is also necessary for some people to do plain speak.
Thank you, judges. I'm just going to summarize this, and in particular because I want to present a challenge to MCIA and Madhukeshwar and Niti. And I think both the judges have effectively said that see if you can curate a program of the right individuals, both locally and perhaps internationally as well. So that's the challenge to the both of you to think about. Okay, Tejas, you had a question.
I just wanted to share, I can hear, so I just wanted to share my experience with National Judicial Academy. I've been going there regularly, and I find that there is also resistance somewhere in learning, and it's called workshop and resource person and roundtable. But what I was thinking is that what Justice Muralidhar said about having a training program for former judges, because the focus for National Judicial Academy is more on the sitting judges who are going to decide the 34s and appeals against those matters. So it's more about how judicial intervention in arbitration should be limited. But where we see the difference is when we have heavy reliance on former judges as the arbitrators, and we see different arbitral styles when we have different tribunals. Can we have a uniform standard of the arbitration in India which we follow in abroad? So is there anything which we can do where we can invite all the arbitrators and senior arbitrators at that age to sit together and deliberate on that matter?
Mr. Karya, I think it's a very lofty idea. The only thing is, what Justice Muralidhar said is the actual reality. That those who have actually conducted trials, let's say, I don't know what was his tenure on the original side. I had about 2.5 years, of which 1.5 years I was senior judge. And he too had a fairly long run. So we have conducted trials, I don't know how many of them, and we have written final judgments, and it takes a particular talent even to get down to doing that, because both were purely appellate judges, mostly Supreme Court judges, but coming down to that, and you had to do a lot of learning yourself. So that receptivity of the mind is very essential. So from what I hear in the arbitration circuit is, there are those who have had this experience, and there are those who are willing to do this and learn it. But there are those others again who have not done it, who are not willing to do it, and it's going to be difficult at the age of 65.
And I should add to this, Tejas, case management. Actually, we need training of former judges on case management. Serious training. So, and some of them need, we can't call it court management, but because the arbitrators are so busy. I know arbitrators who have cause lists. So
let me,
which is an Indian phenomenon.
So let me answer this at least in a minute. But so I think the point on arbitration bar came up. And I think one thing, at least the practitioners here, a lot of them are sitting here, Naresh, Vikas, Tejas, myself. We have actually set up something called Indian Arbitration Forum, which is nothing but an arbitration bar in its sense. And the first things we developed and published along with the Commercial Bar of England and Welsh and MCIA and many other institutions, CAC, ICC, is case management for conduct of arbitration. Because law gives you law, rules gives you rules, but both of them says arbitrator can conduct it in his own manner or her manner. So we actually have published rules, including procedural order for case management, and now we are even coming up with a draft award. So in some sense, some element of work has been done by Indian Arbitration Forum as an arbitration bar, and then create that ecosystem around it. But maybe they can come up with more courses and maybe consistency across tier 2 cities, as Judge was also mentioning. So I'm just trying to give that 1 minute.
One constant thing that we hear from lawyers is the judge doesn't lose the habit of CPC Evidence Act and is insisting on certain norms being followed, and also not knowing how to control a witness. So all these things are, because it's actually relearning for the former judge who's now going to be an arbitrator. Yeah.
Yeah, but only one comment here.
Yeah.
See, I think a time has come because now we're talking of, accreditation of arbitrators. And if we can create an ecosystem wherein we have kind of a continuous legal education, it's training of the retired judges, because we encountered a very strange phenomena. John is sitting here, who is going to start the Royal Institute of Chartered Surveyors program for ADR in India in construction space. And we conducted certain trainings because at that point in time, Schedule 8 was still in force. And when we joined hands with them and set up those programs, we realized that there was complete dislike amongst the retired judges to go through a 16-module program on construction law. So we had to strip it down for non-judges to 16, where you write an award, you write an exam, RICS evaluates it, and after that, we had to have the capability of the judges, because the reality today is that you take out most of these retired judges from the system, you will have a vacuum today. That's a reality. And therefore, we started having those 4 modules, only don't write an exam, but attend those modules, specializing on, and we had engineers and contract managers coming in and giving those sessions. But then we still had only 4 or 6. So that is something which is so critical. And if you look at the National Judicial Academy, this whole arbitration thing is now a part of the commercial courts training. It has to be taken out, as Justice Bhat said, as a specialized program. So this is more of a capacity building exercise within those specialized areas of decision making, which I think is so critical for imparting that mindset.
It sounds like we have a clear consensus in the room.
Yes.
And that consensus is that training is necessary, both for the members of the judiciary that are still practicing as members of the judiciary and those that have retired. The training may be slightly different, but that's something that we can certainly look at. Now, if... let me just finish one thought, if I may. And that is just to share the Singapore experience. I know Singapore is held up as the sort of, in Asia, as a standard in terms of arbitration. So I've been practicing since the early 90s in Singapore, and I can tell you there was a period where the very same discussions were taking place in Singapore about how judges were not getting it right. Judges were still hoping to do, in their view, justice and interfering with awards. And it took multiple actions on the legislature's part to basically effectively overturn some of the judgments that were there. It also took what we're talking about right now, training for the judiciary in Singapore, to finally get to a stage where the judiciary is now viewed, Singapore judiciary is now viewed as being pro-arbitration. So I think this is a journey that jurisdiction has also gone on, and I think it's a good time for us to have this discussion.
Just one, but I was talking to this UK Raja, and his suggestion is don't call it training. Then you will achieve everything.
Okay. Sorry, I interrupted the gentleman in the suit right in front.
So, since we are before a very distinguished panel here, couldn't just register the query. You know, some of the members have been part of the committee. So just a small little question comes to the mind. How is there a roadmap for the arbitration, bar that we are looking at? Or, of course, the full-time arbitration lawyers is definitely would take some time. Is there a timeline that the committee has, or is there any, are there any thoughts on that?
Are you talking about the present committee?
No, present committee, of course, is privy to the arbitration issues and the matters. So, my Lord Justice,
Yes.
but refer to,
Culture of arbitration.
culture of arbitration.
The culture of arbitration ultimately emanates from here.
In the mind, of course, of course.
So like I was mentally thinking out when Mr. Atul Sharma was saying about how retired arbitrators, retired judges need to be trained. Well, one good thing which has happened out of the arbitration amendment is the squeezing of timelines, which means whatever massive, at least in domestic litigation, whatever massive documents you might have, the arguments are limited to a certain number of days. So lawyers have had to retrain themselves. And I wish that kind of thing is done in the courts, because the courts are woefully overburdened with interminable arguments. That is the culture which prevails in the country, unfortunately. Even the smallest of application is fought tooth and nail. Therefore, until we get out of that culture, train ourselves to be precise, and we reach a stage when we have time limits for arguments, we have time limits for not just filing the claims, and set time limits for the award, but time limits for everything. Oral arguments. If the arbitrator is to be the center, the tribunal is to be center and in control, it is necessary that the arbitrator is trained and informed and resourceful enough to control the proceedings, control the witnesses, and even control the lawyers. So it's important. Otherwise, this culture that we speak of will be just an illusion.
Just adding, I think, of course, it might just also include controlling the length of the briefs as well as.
Yes, absolutely.
Thousands of papers, documentation, unless you.
No, documentation is something one cannot avoid, because when you're talking of technical disputes, there are masses and masses of technical data, whether it is in construction arbitration or repetition. Yes. Those are devices to cut down. One cannot cut down the documentation. That is the party autonomy part. But the precision and brevity in argument is very essential. And I think that's where this is heading to. We have to look at that. Yeah.
And on that note of timeliness, we have come to the end of our time for this particular of this panel. Will you join me in thanking the panel in the usual way? Thank you, judges, for your time this morning. Vyapak, will you?
Thank you. I would now like to invite Mr. Vyapak Desai, co-chair of the MCI Council and partner at Nish Desai Associates, to give the vote of thanks.
As Nish mentioned, I think even if we start late at MCI, we end on time. So I'll not take any more time to end this session, but I should definitely thank Justice Bhat and Justice Muralidhar for taking this time, and more importantly, the audience, because you are actually standing up against India, Pakistan, and you are here. I think we could not have got more brave and more confident and passionate to arbitration audience today in this room. And thank you all the sponsors here, I think, who have supported this conference, and more importantly, Madhukeshwar, Neeti, Dinah, Charvi. I think I don't know who else in the team, but to do a 6-day event with a Saturday, only one Saturday, not 6 Saturdays. That's generally what India does. Working days between Bangalore, Bombay, and Delhi is incredible and unheard of. So, congratulations everyone to get this event through. And only one point, when I think both the chief guest and the guest of honor talked about Arbitration Council of India. And only thing I wanted to say at that point in time was that when the amendments were proposed, it was called Arbitration Promotion Council of India. And the most important amendment they did was to drop the word promotion. So I don't know what was the intent behind the dropping the word promotion, but I hope it doesn't come out in the actual execution of it, and they do that what it was meant as per the proposed amendments as Justice Sri Krishna suggested. So thank you everyone. I don't want to take any more time, and thank you again Nish and everyone to be part of this conference. Thank you.